Namaste and welcome to today's 10 p.m. Jaipur Dialogues show. And today I have for you Sai Deepak with me. Most of the people who have been associated with Jaipur Dialogues earlier know Sai Deepak, but then we have had almost 50,000 people joining us the last 6 months and they do not know Sai Deepak. And I'll introduce him. He is a mechanical engineer from Anna University, Chennai, who chose to join law in IIT Kharagpur. Yes, it may be news for you, but IIT Kharagpur does have a law degree now. And after graduating from there, he came and joined practice in Delhi High Court and the Supreme Court. He specializes more in IPR and corporate law, but most of the people here in Jaipur Dialogues would know him for his advocacy of the Shabarimala case and a number of other Padmanabha Swami case, and his general espousal of the Indic causes. And today I have him here for a very special and rather, I would say, a deep discussion on a deep subject, and that is, it is often called in law parlance as decoloniality, but I think most people would recognize decolonization as a subject, and this is regarding decolonization of the legal system. Namaste, Sai Deepak. Welcome.
Namaste,
I was wondering whether they would leave you off India.
It's a pleasure to be with you, sir.
Okay, great having you here. I think this is a subject which briefly discussed earlier also, and I believe you are in the process of finishing a book on this aspect, decoloniality / decolonization of the legal system. And we know that the very term law comes from church, and the English common law is basically church-based. And even our constitution was written, actually the draft constitution was written by a British civil servant, Sir B.N. Rao, and it was on that basic draft that the entire Constituent Assembly debates took place. And your position, as I understand, is that all the concepts that come with this system of our legal system, and they recognize India as a nation state, but you argue that India is a civilizational state. And all the concepts, identity, religion, gender, environment, education, citizenship, fundamental rights, and minorities, all of them need a different context. So let me have your opening statement on this.
So, I think about 2 or 2.5 years ago is when a specific and a very noble movement started asking for the amendment of the Constitution, specifically Articles 25 to 30, largely on the ground that the manner in which these provisions have been crafted and interpreted by the judiciary have translated to pitting the Constitution against the civilization and Indic values. And that led me to explore the premise of that particular position. And the more I read about the Constitution, the more I read about the history behind the drafting of the Constitution, the one thing that became fairly clear to me is that the document is vastly misunderstood as, let's say, a document which has been crafted and put together by brown sahibs, so to speak. There is no doubting the fact that most people who were involved in the drafting of the document were necessarily a product of their times. So going by that logic, from Mahamana to K.M. Munshi, everybody can be accused of being a brown sahib. And that is why I felt that caricaturing of the Constituent Assembly, its members, and the entire process was perhaps a bit too exaggerated. And exaggerated not for bad reasons or wrong reasons, but exaggerated because of the sense of angst and desperation that comes as being a part of the Hindu society in India today. So while the triggers of that particular sense of exasperation are valid and justified, the conclusion may not be necessarily justified. And therefore, I felt that the place at which that anxiety lands is not supported by history, is not supported by the Constitution. And so the more I read it, I realized that while the document may not be entirely pro-Hindu or pro-Indic and pro-civilization, there are several parts of it which clearly show that there is a marked tilt towards the civilization. At the very least, it's a 51-49 tilt. Okay, on important questions of identity, on important questions of citizenship, on important questions of protection of our objects of worship, such as the cow and whatnot. Okay, and on important questions such as even caste. Therefore, I undertook a certain exercise which required me to read as much literature as possible, and multiple commentaries on the Constitution which came out around the period of the drafting and post it immediately. Not the ones that were authored in the 70s or the 80s, but the ones that were published between, let's say, 1940s and 1950s itself by several leading judges or, let's say, practitioners around that time. And the more I read it, the more I was I was informed that maybe this document requires a revisitation. So that's the trigger for this particular exercise. Assuming that this particular exercise leads me to a conclusion where I come to the finding that no, this is not exactly a civilizational document, that it is indeed an Anglo-Saxon document. The good part about a legal document is that it is malleable to interpretation. Okay. Therefore, the idea is to say the alternative argument is if it is not a civilizational document, then it must be interpreted as a civilizational document, because then it does justice to the ethos and pathos of this particular civilization, and also let's say, unshackles it from the burden of coloniality and colonization, wherein you continue to think like the white man whose job it is to civilize and reform the native savage. Okay, so the idea was, one, if this is not the original intent of the Constitution, then you've come far from the original intent. Assuming this was not the original intent of the Constitution, then this must become the intent of the Constitution, the manner in which it is interpreted today, is my basic submission. Because if people keep saying that the Constitution is a fluid document which must reflect the will of the people in the times that we live in, sure, then we live in a time when, we live at a time when people have started believing in the fact again that Bharat is a civilizational state, so to speak, because it is the successor of an ancient civilization and continues to be a living civilization. It is not a fossil, it is not dead, it is certainly not, let's say, dead wood, so to speak. So, twofold argument being, either the document is fundamentally a civilizational document at the very least, or it must be interpreted as a civilizational document. And the framework that I use to effectively arrive at this particular conclusion is a framework that I was recently introduced to by a very good friend and a scholar of decoloniality, Ms. Indu Vishwanathan, who is a doctoral scholar at Columbia University Teachers College. And that framework has effectively given me perhaps a better analytical tool to justify my positions.
Yes, I believe that analytical tool would look at the basic premises of any civilization, or even the basic premises that lie behind the nation states, because nation state is basically an ethnic concept. The civilizational concept is a very plural concept. And of course, there's also a nation concept of nation among these Islamic countries, and that is based on religion. That is the Ummat. And I also have another observation. You're free to correct me if you like, is that I think the Constituent Assembly was probably in so much of a hurry to frame this document that it relied largely on the Government of India Act 1935, and so it ended up making a document which had some bits and pieces from some places. It picked up fundamental rights from USA, it picked up some directive principles from Ireland, it picked up parliamentary democracy. In fact, parliamentary democracy, a lot of commentators have said that the parliamentary democracy was chosen only because India was familiar with it, not because India needed it the most. And so the basic template still remains the Government of India Act 1935, and that served the colonial interest. And because that is the basic template, so it had to be a colonial document with some copy-paste and some kind of a lipstick applied over it. What's your take?
So, in fact, in defining constitutional morality in one of my pieces, I had the opportunity to deal with this specific allegation that was leveled against Dr. Ambedkar during the course of the Constituent Assembly debates. I think it was in 1949, almost on the perhaps the fag end of it, when he had to face this particular accusation. that what have you done? What is so Indian about this particular document? Because at the end of the day, it is largely a chapeified version of the Government of India Act of 1935. To which he candidly admits, yes, the administrative aspects with respect to the relationship between the union and the states and the arrangements, let's say the bifurcation of subjects, these are issues which are largely the product of the Government of India Act of 1935. He doesn't even run away from that. He owns up to that particular accusation and he says, please tell me, in the absence of, let's say, another form of political organization other than democracy, which is currently viable and functional and feasible in the times that we live in, please tell me which other form of political organization would you have chosen to stitch together this massive subcontinent with its diversity and with several princely states on the bargaining table. How do you hope to do justice to all their aspirations without having some kind of a give and take arrangement, which is effectively what the Constitution stands for the better part of it when it comes to a relationship between the union and the states? Okay, so he makes that statement. The question that, according to me, is which is more fundamental, is on aspects of fundamental rights, on aspects of fundamental duties, on what are the basic constitutional values that the Indian Constitution subscribes to, what are our sources, what is the repository that we chose to tap in on, what are our inspirations. The Czech Constitution, the French Constitution, the Irish Constitution, the American Constitution were certainly sources of inspiration to address questions of fundamental rights and to address the question of judicial review. They certainly discussed each of these aspects. However, when defining the terms that have been sourced from other jurisdictions, from Sarvepalli Radhakrishnan to K. M. Munshi, they are very clear that the concept of morality must be traced to the concept of dharma as far as India is concerned. Okay, so the skeletal structure that we chose to impose upon ourselves through the document called the Constitution is certainly a structure that was in vogue then. There is no doubting it. And so the point is, if we go back to the question of do we appoint somebody as the Chakravartin, between the 500 and odd princely states, who would have been the Samrat or the Emperor? How would we actually address or resolve those questions? If we wanted all of them to be a part of the Indian Union, then there must be a better framework which all of us agree to, which is more participative in nature, which addresses everybody's egos and aspirations. Therefore, according to me, a parliamentary form of democracy, apart from being in vogue at the time of the Indian Constitution, was perhaps the only way forward then. I don't think anybody was in a position to think of anything else because the British Empire had significantly weakened and they just wanted to ensure that we have a structure in place which ensures some form of continuity so that the society doesn't fall into chaos. You have some law and order structure, you have some answerability and accountability, you have the judiciary to enforce a certain form of rights, you have an executive to take a certain decision, you have a legislature that represents the mandate of the people. So according to me, whether we were in a position to think of anything else or not, democracy and parliamentary democracy was certainly something that India was perhaps ripe for and best suited, given that it was putting together a multitude of aspirations. So I don't think there's a problem with that at all. The question is, what is the overall identity that we choose to impute to this country? Are we going to rob it of its civilizational identity using the Constitution as an excuse? Are we going to sever its relationship with history, citing constitutional values such as secularism? These are central issues. And the document and its history tells me that nowhere was it the intention of the framers of the Constitution to sever the document and the future of the Indian modern republic from the civilizational history that it is a successor of. That is largely the product of the Nehruvian, secular, socialist, militantly stupid school of thought, okay, which chose to dissociate the Constitution and its intent from its history. So I don't think we should impute Nehru's stupidity to the framers of the Constitution. As I've said before, his contribution to the Constitution is not as much as people make it out to be. In fact, even Dr. Ambedkar had to, let's say he was drawing on the work of Sri B.N. Rao and on the work of the other members of the committee who elected him as the chairman. He received a lot of comments from February 1948 to October 1948. So the Constitution, one, is certainly not the product of Nehru, and secondly, is certainly not the product of any one man. It is the product of an entire group of people. So I think the reading of the history of the Constitution is mandatory to bust quite a few myths, because what came into force on the 26th of January 1950 is not the document that we relate to anymore today, because the document has been the subject of multiple interpretations which are anti-civilizational. Okay, therefore the idea behind my work is to say, let's go back to the basics and let's do justice to the original intent and still remain contemporary.
Okay, let's discuss the aspect of fundamental rights. The fundamental rights, it's a very good progress made, definitely. But the civilizational state that you talk about, and India as a civilization has always had duties paramount and rights as adjunct. In fact, if you read either Mahabharata or the Ramayana, the rights are given to a people, the rights are given to the king, the rights are given to a rishi, in order to make him fulfill his duties to the best of his capacity. That is the concept of rights. Of course, there are certain inalienable rights, the right to live, the right to survive, all that is there. But then even punishments are graded according to the privilege that you hold in the society. That is the kind of system that we had. But here we find that the concept of duties, the code, the dharma that is associated with various activities was not really made enforceable. One, in fact, there wasn't even a mention of duties. That also came as some kind of a communist overtone or the socialist overtone from Mrs. Gandhi. And that was a different context altogether. So do you think we missed a trick there? If we had included at least that aspect of certain codes for everyone and made it enforceable, and or rather seeking of rights made contingent on fulfillment of your duties, something like that could have helped better?
So one, the conception of the dharmic society as a duty-based society is certainly not wrong. However, the dharmic society, according to me, and as I've just had an opportunity to share in the previous podcast, is more of a restraint and balance-based society. The idea is to strike a balance between what you want and what you're expected to do, and hoping that you have the good sense to understand that you're part of a unit and that you don't function individually. Okay, so therefore the problem, I think, is if we think of it as entirely a duty-based society, then there's a decent chance that we end up giving it the hue of an oppressive, control-based society. As opposed to that, the society effectively functioned in a way where everybody is conscious of his obligations. Okay. And as opposed to having an enforcement mechanism where you're supposed to do it, failing which you die, the idea is do it because it is not just in the society's interest, it also perpetuates your own pride, and therefore a sense of pride is imputed to each of those identities. So I think a sense of clannish pride and a sense of, let's say, jati-based pride or varna-based pride was given to ensure that there is some kind of incentive to continue performing those roles. So someone who is supposed to teach and someone who is supposed to educate people must learn humility, and therefore he survives at the munificence of the rest of the society. Each of these checks and balances were put, wherein you have an obligation, you have a right. So because you have an obligation to teach others, you also have a right to expect others to contribute to your survival and to your existence so that your basic needs are fulfilled. So I do believe it's a fair balance between the two. And whether the Constitution has done justice to our notion of duty, perhaps I think the framers of the Constitution were of the view that the traditional society, or the traditional Hindu society, which was the bulk of the country then, at least more than 85% of the population was Hindu, still functions on the basis of social opprobrium and listens to what the society says. So there is a decent chance that given the duty consciousness which already existed as part of that generation, they did not see the need to codify it as part of the Constitution. Because if I can say that the previous generation was much more conscious of its societal duties, I can be fairly confident that the people who lived in the 40s and 50s are way more conscious of their societal duties than the generation of today. Okay. And therefore, perhaps the focus there was duties already exist in an unspoken manner. Why don't we also carve out and crystallize certain rights? Because these rights have been brushed under the carpet and completely dismissed under the experience of the colonizer. Therefore, perhaps we need to ensure that these rights continue to be available and the Indian government doesn't become the successor of the British government to push under the carpet these rights. So I would say that the emphasis on fundamental rights is largely a reaction and a response and a consequence of our experience under the colonizer. However, today I would say, as opposed to blaming the framers of the Constitution for not putting sufficient emphasis on duties, why don't we do it today and make it enforceable? Because if constitutional morality seems to be that particular creature that keeps evolving and keeps framing the rules as it goes along, why does constitutional morality never translate to, let's say, imposing certain obligations on people and says that there is a certain limit that needs to be drawn as far as your individual right is concerned? Unfortunately, even judicially prescribed constitutional morality seems to be pushing individual freedom at the expense of societal duties. That's where the problem is. The watchdog of the Constitution itself believes that individual rights must prevail over certain societal expectations. That affects when it comes to religious institutions, that has a bearing on environment, that has a bearing on climate change, that has a bearing on all sorts of things. Okay, so assume for a moment that in the times that the Constitution was framed, they did not feel a need to do so. And since we are feeling the need to do so, what stops the government with coming out with something that says fundamental duties must be treated at par with fundamental rights, and there are certain obligations that people can't escape, and it is as judicially enforceable as fundamental rights? Let them make that statement. I don't see that happening. And that's not happening largely because the society is yet to get the jolt of its life, a polarizing experience, where it realizes that without duties, this is going to be an utter chaos, and we are moving towards utter chaos. Climate change and issues such as climate change are going to reinforce and bring back the importance of duties into our social lives and personal lives, and that's going to happen. That is inevitable. I just hope we don't wait for some kind of a natural calamity or a catastrophe to hit us before we start thinking on those lines. I think we've already been hit by one. We might as well start waking up.
Let's move to another area. And before that, of course, let me request my viewers that we will stop this conversation around about 35 minutes of this live webcast. So you please keep your questions ready and keep shooting your questions. And also, please like, share, and subscribe this video. And wherever possible, do please contribute to us. Okay, you mentioned environment. All right. Now, what has happened is that this expansion of the concept of constitutional morality seems to, and combined with the two perversions that were introduced through the 42nd Amendment, socialism and secularism, it seems to have imposed exactly the opposite kind of duties on the populace to uphold socialism and secularism, combined with the constitutional morality dictates that the judiciary keeps prescribing. The three very important aspects of the civilizational state seem to have been completely undermined. And these are religion, education, and a privileged position to minorities. Your comments?
So, I think the undermining of the native faith system is the reason for the other two, according to me. There is a false sense of guilt that perhaps the Indian state has embraced post the partition, which it need not have, because the Indian state is the victim of the partition, it is not the perpetrator of the partition. Okay? And that informs both its treatment of its minorities as well as the manner in which it conveniently fashions this monster called secularism. And I call it a monster because it has gone out of hand, and anything that goes out of hand is a monster. Okay, so I believe that the history of the formation of the Indian state post its cleaving thanks to a religion-driven partition needs to be squarely met and addressed and drilled into the minds of everyone so that they know who is the victim and who is not. because today everybody gets to play the victim based on hoaxes and, let's say, fabrications of history. Whereas this is not even that far in history. It's barely 73 years away, not even a century ago. And we should be talking about it. And what led to it, how many decades was it in the making, is something that people must know, because people seem to be under the impression that partition happened overnight, that there was a massive riot overnight and then it happened. It was in the making at least since 1905, that is at least for 4 decades. And the fact that these things simmer slowly and lead to one final moment is something that this generation has still not realized. And therefore, when the history of the partition and the events that led to the partition become clear to the people, automatically it will put pressure on the state to mend its ways when it comes to secularism and its pampering of, let's say, certain sections of the society in the name of social justice and whatnot. Okay, and when it realizes that the integrity of the Indian state and the existence of the Indian state both are contingent on the survival of those faith systems that worship the territory, that deify this particular geography, that elevate it to the status of Mahabharati, only then its attitude will change. Unfortunately, as I said, the dispensation that took over immediately after independence was as antithetical to all these ideas as it can get. It's almost as if you're looking at the North Pole and the South Pole, you're poles apart. And therefore, and the worst part is, every act of omission and commission of that particular dispensation, the Nehruvian dispensation, has become the benchmark against which everybody else is judged. And unfortunately, I don't think even non-left dispensations have come out of that particular mentality. And all they want is to occupy that exalted space, as opposed to challenging the values that that exalted space represents, and to say that all that you believe in is utter trash and bilge. And you have led to a situation where you have perhaps laid the foundation for the next wave of partition. That is something that no dispensation seems to have the courage of the conviction to say bluntly and act on it and deal with it. So when there is that realization, and when there is a political incentive to act on that particular belief, I think things will change. And therefore, I don't think it makes sense to put faith in political initiatives. It makes sense to put faith in civilizational and societal initiatives, because this particular movement has to be ground up. And every such movement has always been ground up. And when that happens, it will throw up a couple of options. And those options will hopefully push the envelope on this front and get the job done. Unfortunately, today we have put all our eggs, including the civilizational egg, in the political basket. Okay, as opposed to putting the political egg in the civilizational basket. Okay, so since our priorities are so skewed and so distorted, clearly we will continue to suffer the consequences of secularism and socialism and whatnot for another, let's say, maybe 5 or 6 years, until we realize that I think we have been digging our grave patiently for 73 years. And all we now need is ek dhakka aur do, and we fall into that grave. Okay, so I think we're just waiting for that.
Yeah, that's very well put. Actually, my book that is going to come out, in fact, that was to come out, and then I actually withdrew it from Bloomsbury after Bloomsbury withdrew something. Then that explains that entire sequence of events that led to the partition and that led to the 370, and that finally culminated in some kind of an unbreaking India moment in enactment of CAA and nullification of 370. But that's only a part of it. That is only the legal part. And as you rightly said, that it has to go into the civilizational basket, and the politics has to be impacted by civilization and not the other way around. Again, I remember in this context, there were two things that Dr. Ambedkar had said, and if they had been followed, I think the civilization would have been very different. But of course, you said that I totally agree with you, that even today, Nehru is criticized, Nehru can be criticized, but nobody dare criticize Nehruism. And two fundamental propositions that Dr. Ambedkar made. One, before the partition, that you make a clean exchange of population. That was not adhered to. That was also would have been a very politically savvy thing to do, because if somebody had, Congress had come out of their, what is called self-reproach, and acted as representatives of Hindus, which actually they were. In effect, they were only representing Hindus, because Muslim League had taken away the entire Muslim bloc. But even then, they kept pretending that they were representing everybody. And in the process, they got neither the baby nor the bathwater. So both got thrown out. And the second proposition that Dr. Ambedkar had made was that you make Sanskrit the link language. I think that was a very, very sound proposition that was also not heeded. So I agree with you completely. And since we have a lot of questions, so what I will do is that because the essence of your statement is already made out, we will move straight to the live questions and answers. And those questions will reflect on your screen.
Yes.
And I will read it out also for you. And then you can answer. And you can answer them directly in the sense that if you're going to make them too long, then you will continue to sit here for 1 hour. So
Right.
please make them brief so that we are able to take all the questions. Anu Lakshmanan, your take on PIL in the SC file to remove the word socialist and secular from the Constitution.
This is something that need not have necessitated a PIL, and I think that the government itself should have done it. But unfortunately, I think the petitioners realized that the government may be comfortable removing the word socialist but not secular. So perhaps that's what has driven this particular PIL, but I don't see too much of hope from the judiciary when it comes to the removal of these terms, because some convoluted justification will be found to retain these words in the preamble. I don't see it succeeding. I wish all success, but I don't see it succeeding. If I'm proven wrong, I'd be the happiest.
Okay. Yogesh Soman, isn't it true that there is no clear definition of freedom of speech and expression, and where it divides anti-national aspects in the IPC, shouldn't it be done?
There is never going to be a clear definition of free speech and expression in any jurisdiction. These are values which are incapable of a concise and specific definition. And by definition, they must be broad, according to me. So I don't think the absence of a specific crystallized definition is a problem there. And the relationship between certain aspects of IPC, which puts fetters on free speech and expression, is fairly clear. The only thing that perhaps we may want to have a discussion on is how much are we allowed to criticize religion, how much are we allowed to criticize the history of religion and the conduct of a certain community or communities. That would effectively take us to discussion on sections 153 and 295A. But even there, I think there are some fantastic judgments which have made it abundantly clear that criticism of a religion is permitted. Only deliberate and malicious, let's say, statements which are made against a religion are problematic. So it is absolutely perfectly justified for anybody to write a book on any religious figure and say why they disagree with it, as long as they don't let loose words without any kind of basis. There is enough justification for it. In fact, Sri Ram Swaroop's books on several religions are in public domain precisely because the law allows it. Otherwise, I don't think these books would have been published. So there's no problem, according to me, between the relationship of free speech and expression and certain provisions of IPC.
All right. Okay. Next question, Anu. How does one address the conflict which arises between Article 21 and 25-26?
No, so this is a question that Anand Ranganathan had also raised as part of the Art Festival this year, where he said that how do you reconcile the relationship between right to life under Article 25 and 21 and 25 and 26? Frankly, I don't see what is the basis of this particular nexus, because Articles 25 and 26 clearly say, at least 25 says that it is subject to the other portions of the other provisions of Part 3. Therefore, even Article 21 acts as let's say a lever, or let's say some kind of a check against 25 and 26, which is to say, if there is a religious practice that necessarily affects right to life in a tangible way, for instance, if you cite scripture to force someone into committing sati, if at all there is a scripture for it, or if you cite scripture or you claim that there is a scripture to kill someone, then that's where obviously 21 prevails over 25 and 26. But by and large, there have been very few instances where right to life has directly come into conflict with 25 and 26. Perhaps these days that particular this argument is being made in the context of Pashubali and whatnot. I believe that the invocation of Article 21 for the purposes of 25 and 26 to seek a ban on animal slaughter, or let's say sacrificial slaughter, is unwarranted, because then certain institutions will completely lose their identity, which is their right under 25 and 26. So if you really have a problem with animal slaughter, then we might as well all become vegetarians and then talk about sacrificial slaughter. As long as that's not the case, I think it's rank hypocrisy and it smacks of elitism. which is precisely the comment that was made by Justice Bobre when the Pashupali petition came up before him. So I think it's a fair point to make that anybody who wants to talk about Pashupali must effectively first have a problem with non-vegetarians and non-vegetarianism, because obviously temples don't consume as much as the rest of the society, or any religious
Right.
institution consume as much as the rest of the society.
Okay. Rajiv Podar is asking, would you say that ganja ban is anti-Hindu in nature and a relic of Islamic and Western imperialism? Should ganja legalization be a part of decolonization project as well?
I honestly don't understand the obsession with ganja because I honestly don't know why is this question coming up about ganja in so many places as part of decolonization, as if these are our priorities. I have represented certain NGOs when it comes to the challenge to the fetters on the use of ganja for medicinal purposes and agricultural purposes. But frankly, I think there is a lot to be done in terms of research to make the statement that ganja should be back as a recreational substance and all that, because there is enough literature to say that even if it is not as harmful as other drugs or narcotics, it is an entry-level drug. Okay, so there is some literature even on that front. It may have been removed from those categories of substances which are harmful or lethal. I'm not denying that at all. But whether it leads to something else, so what do you do? But then the argument is, if you've permitted tobacco and if you've permitted alcohol, what is the problem with ganja? So there is a question of relative hypocrisy between tobacco, ganja, and alcohol. So considering that, perhaps ganja may be better than these two. Let me be very, very clear. I'm a teetotaler. I don't smoke, and I certainly don't see myself consuming ganja. Not that I'm taking a judgmental position. I don't have a skin in this particular game. I have no vested interest in the outcome. I'm just making it clear.
Okay. Next question. Based on your, this is Rashin Jhala. Based on your discussion with influential people, maybe in the current government, is there any inclination, interest from the government towards introducing the concept of duties? Because if not BJP, then who? Okay.
I have to say that I have no discussion with any influential people, especially in the current government. I'm a nobody. I'm a rank nobody. I'm a fly on the wall. Okay, I just keep observing, and I don't
I think
see.
I can answer that better.
Please, you should.
The answer is capital N, capital O. No. Okay. Let's go to the next one. Arvind Ramanathan. OIC often invokes that freedom of religion is a fundamental right from Muslim personal law, board, polygamy. What is your opinion?
He is entitled to raise that particular right as long as the state does not take a position against polygamy. The state seems to have taken a position with respect to polygamy only in relation to Hindus, but when it comes to others, it hasn't. That brings up obviously the pet peeve of uniform civil code. While I understand that certain aspects may be uniform and need to be uniform across certain communities, the unfortunate problem is that I'm yet to see a clear draft of what the Uniform Civil Code is intended to achieve, what are its metes and bounds. Until I see a document such as that, I am not going to walk into the trap of Uniform Civil Code, because I don't know what is its impact going to be on Hindu lives and Hindu traditions and Hindu personal laws. Because as I've said before, already we know only about Mitakshara and Dayabhaga as far as our succession systems are concerned. And even there, the Hindu Code Bill nationalizes and gives state endorsement only to the Mitakshara laws. In the process, several regions have lost their personal laws and several communities have lost their personal laws. I don't want the Uniform Civil Code to be a second exercise in that particular regard. So, if you have a problem with Muslim polygamy, is it because they get to marry more people, or because do you think polygamy is bad? If it is the former, then you should ask for polygamy for Hindus also. If it is not, then you can even ask for, let's say, a fairly uniform treatment of women across the board without necessarily going for a uniform civil code. Unfortunately, we seem to think that uniform civil code is the magic bullet. I don't think it is.
In any case, the number of women will always remain finite. Your views on the recent judgment given by the Supreme Court on the HSA 1956?
That judgment of the Supreme Court, the three-judge bench judgment of, I think, Justice Arun Mishra, is merely clarificatory with respect to a certain provision. I don't think a specific view on that particular judgment is warranted. The only question that every Hindu seems to ask is, Why is this particular provision where the daughter gets equal rights as the son limited to Hindus alone? That's a valid question. That is not something that requires a comment on the judgment. That's a question that requires a comment from the state, from the government or the state.
Right. Okay. The name is very interesting. Shaitan Square. Sai Deepak ji, I am following you from Op India livecast to here. Okay. So I've got one Op India follower coming here. My question is, can we remove the word secular from the constitution next 20-25 years? What is your view?
We must, but I don't know if we will. If the government starts showing some commitment towards civilizational agenda, or let's say civilizational goals, then it doesn't need 20-25 years. It can be done next year. Just as the government was very eager to come out with a revised diluted Article 370, which I welcome. So it's equally possible, or at the very least, let the state define it. Unfortunately, I don't think they're thinking on those lines.
Okay, great, Sharon. What's your view on the Environment Impact Assessment Bill 2020 with respect to Indian view of protection of nature?
In fact, I happened to read a brilliant piece by one of the researchers of the Indian Collective Trust on the EIA 2020, and there are certainly some serious concerns about the dilution of objection mechanisms before land is acquired for developments and projects and for industrial projects. I must say that I have not read the bill in entirety, but my reading of some of these articles tells me that it could lead to further industrialization and what we know as urbanization at the expense of environment. That is my view. If somebody calls me a tree hugger, so be it. I love trees, I love greenery, I love nature. So there's no harm in taking that position at all.
Okay, yes, let's all be tree huggers. That's a better position. Next question, please. Anita V. Very interesting discussion. Thank you, Saiji, Sanjay ji. Thank you, Anita ji.
Thank you.
Next question. Steve Plant Babai. You'll get a lot of these pseudonyms here. Sending love to our proud Bharatiya, Apara Chanakya, Telugu Pride, the one and only JST. Are you Telugu? I thought you were a Tamil.
I'm a Tamilian from, I'm a product of undivided Andhra, but I love Telugu as much as I love Tamil, and I read the script even better. I can't read Tamil. I'm hoping to. I read and I love Telugu a lot. That's a fact.
Your thoughts on the BJP alternative?
I don't think there is one. We don't even have a decent opposition. Where is the question of an alternative to the BJP? That's not happening in the near future. I hope that the current dispensation realizes the windfall that it has and doesn't squander the opportunity that history has presented to it after several centuries. Hopefully, they are alive to the unique position that they enjoy, something which even Shivaji Maharaj and so many others did not enjoy in terms of lording over almost most of the country with BJP governments across the board. So therefore, they're in a position to effect a change which most, let's say, Hindu icons haven't had the opportunity to. So I hope they deliver the goods.
I can make a suggestion. That question should be asked to Rahul Gandhi, actually. Okay. Next question. When will the temples be free from government?
Ram Jane.
That's very succinctly put. Sachin Mendon. Hello, Deepak. I wanted to know how difficult it would be to have the Universal Civil Code implemented and what would be their positive and negative impact overall.
Sir, I've already discussed this particular issue in other talks. Just search for Uniform Civil Code and Sai Deepak on YouTube and you'll get it. I don't think we must rush into the Uniform Civil Code without having a discussion. I'm not taking a position against the Uniform Civil Code. All I'm saying is, when I supported the CAA, I had understood what the CAA stood for because I had the document in front of me. And I also had the previous bills in front of me to understand what it would translate to. I have not seen anything that spells out the actual contours of the Uniform Civil Code. So it makes very little sense to have just a normative discussion in the absence of some document.
That's right. And actually, there's a lot of misgivings about the Uniform Civil Code. Uniform Civil Code is not one civil code. And in fact, I have written on it a couple of years back that Uniform Civil Code is not one civil code. That article is available on my medium.com blog. You can go and have a look. And that also mentions the points that were made in the Constituent Assembly debate. Bhaswant Gudimela, can revision of history books decolonize our minds?
Revision of history books will certainly contribute to it, but more than anything else, I think changing the education structure and how we choose to produce knowledge and how we choose to teach it and how do we choose to disseminate it, everything is connected. History alone is not enough, but it is certainly necessary. There is no doubting it at all. What is the point of merely decolonizing history without teaching students Indian schools of sciences, Indian schools of logic, Indian schools of reasoning, Indian schools of jurisprudence? So I think when you look at it, please look at it from a holistic perspective of changing the education system. And that's what the national education policy was hopefully, I mean, that's what it was anticipated to achieve. I'm not sure it is going to achieve all of that, but at the very least, in a country like India, after the experience that we've had in the Nehruvian dispensation, something is better than nothing.
All right. Okay. Next question, please. Can we have the next question on screen? Okay. This is SM. If secular is removed without adding dharmic, disaster.
Is secularism without adding dharmic disaster? Not exactly, but adding dharmic would be a bonus. Removing secular would be at the very least desirable. So the minimal expectation is remove secular. The ideal expectation would be add dharmic.
Okay. Next one is secularism itself a form of communalism in India.
It is, of course, it is. It is perhaps the worst form of communalism that Bharat has been subjected to, because it constantly guilt trips you. It requires you to abandon your identity. It requires you to celebrate every other identity. It requires you to reject and deny the history of oppression that you have received. It requires you to deny that you have any value. So yes, it is the worst form of communalism according to me.
Yeah, excellent question. Okay, and there is one economics question. Why 1 rupee coin is still so valuable?
ये आउट ऑफ सिलेबस है, ये मेरी बुद्धि के बाहर है, मुझसे तो इसका जवाब नहीं दिया जाएगा.
Well, out of syllabus, and okay, so that is we have actually managed to finish within the original time allocated by you to us, in spite of Op India taking away 15 minutes out of that. So we have finished exactly a little less than 45 minutes, and that's wonderful. That's because you were able to make such pointed replies to all these questions. And we had a record question this time, so you answered almost 40 questions. I don't know whether you realized it or not.
I didn't actually.
While we were at it, there is one question that has come. What are the immediate judicial reforms you want this government to do? Some low-hanging fruits, but something to start with.
First, I think incentivize more, let's say, brilliant and bright practitioners to join the judiciary. Ensure that the judiciary is sufficiently paid in terms of its remuneration. Because you have to realize that if you happen to be a decent lawyer, you stand to make more money than anybody else who occupies the highest judicial office. And therefore, the incentive for anyone to give up practice and join the judiciary is not as much. That's one. And compared to the number of judges per million that every other advanced jurisdiction has, Bharat has a serious paucity of it. And contrary to popular perception, we are an extremely litigious country. Ask me and I'll tell you the number of cases that are filed in the courts on a daily basis. We are not at all a less litigious country. We litigate on everything at the drop of a hat. So numbers, all of this. Because whenever we address the question of judicial reforms, we are only looking at accountability, collegium system and all that. But the system has so many challenges. You have to address all of that. Unless and until you have a judiciary which is capable of dispensing justice as expeditiously as possible, I don't see people having any confidence in the concept of law, in the concept of rule of right, in the rule of law, or in the concept of private property and private rights. So I think that's very, very important. That's a very minimally discussed aspect of judiciary.
Okay, and while you're replying this, 2 more questions have come, which I would request you to answer in 1 or 2 words.
Yes.
Shall we, Paryal, what do you think about the PILs for postponing JEE, NEET? Any legal validity for the demand?
I am not in a position to comment on that because only students are best positioned to address their issues. I don't want to sit and judge on what is right or wrong for them. I'm not in a position to comment on it. So I'll do a Dravid here and then left.
Okay. I can add to it. I think
Yes.
These were totally unjustified. And I've explained it on my tweets. You can go and follow me on my Twitter and see why it is totally unjustified. Okay. Uday Velumichetti, how long before the majority community becomes Zimmi in the real sense?
Hasn't it already become?
Let me tell you one more thing. Anybody who spells Zimmi as Dhimmi is himself a Zimmi.
The Arabic word is zimmi.
No, the Urdu is Dhimmi, Arabic is
Ah,
Dhimmi.
acha.
So don't ever say Dhimmi. As soon as you say Dhimmi, you become a Dhimmi. Simple as that. So that's my reply to that. And with that, I think we'll end quickly, saying thank you to you and thank you to all of yours before more questions come pouring in. And it was wonderful having you here. And
Thank you, sir.
we hope it was very difficult getting you here also. Let me tell all of yours, because they have been demanding that get Sai Deepak for, I think, almost 3 months. And we
Acha.
hope that next time you will give us a rare opportunity. And I promise that I will keep to my time limit. And today is the evidence. Thank you,
Absolutely.
Sain. Thank you. Wonderful having you here. Hope to
Thank
have you
you.
here more and more.
It's a pleasure being with you. It's a pleasure discussing the law with you. And I thank all the audience members for watching this
And
patiently.
just
My
to
apologies.
inform, I'm joining your profession. I've already
Yeah.
applied for a bar
Welcome.
license.
Welcome to the club.
Thank you.
Thank
Okay.
you.